In the previous podcast, we saw that an appeals court justice denied a petition from Scott Barrow, the son of a deceased nursing home resident, who claimed he had no authority to sign an arbitration agreement form that said he was a person duly authorized to execute the agreement and accept its terms. Scott was forced into arbitration where the arbitrator determined no wrongdoing by the nursing home in the violent death of his mother. Now we'll hear what happened when the appeals court took a second look at the case that had closed the courthouse door. Hello, I'm John Roberts, an elder law attorney serving people in Hampden County, Massachusetts. 5 years after the violent death of Elizabeth Barrow, a panel of 3 appeals court justices reconsidered the question, who can bind you to a Massachusetts nursing home arbitration agreement? Today we'll see who can sign away a nursing home resident's rights to make a claim in Massachusetts court. Arbitration agreements are considered good for business because they reduce the cost of insurance premiums paid by corporations. In the YouTube video Hot Coffee Truth, legal experts at the U.S. Chamber Institute for Legal Reform say that arbitration clauses typically do not apply to personal injury cases. They say arbitration agreements prevent frivolous lawsuits and save time and money for everyone. But the arbitration agreement in this wrongful death case added 3 extra years of legal struggle to the grief already suffered by the Barrow family. The appeals court affirmed the arbitration agreement in 2011, but did a 180 and reached the exact opposite conclusion in August 2014. With the 5th anniversary of Mrs. Barrow's death approaching, judges threw out the arbitration agreement and gave Mrs. Barrow's family their day in court, concluding that Scott did not have authority to sign the arbitration agreement on his mother's behalf, and therefore Scott, as executor of his mother's estate, shall be permitted to seek redress in court for Elizabeth's allegedly violent and unnatural death while in the nursing home's care. The arbitrator's decision was thrown out because there was no evidence that Elizabeth knew Scott was signing an arbitration agreement for her as part of her admission into the nursing home. She was not in the room when he signed the agreement. The agreement was not a condition of admission, and finally, Scott admitted that he did not inform his mother of his signing of the arbitration agreement. Elizabeth had appointed Scott to be her health care agent. A health care proxy, as the Supreme Judicial Court previously held, is insufficient to authorize the health care agent to sign an arbitration agreement. Scott did not have a durable power of attorney for his mother, nor was he acting as his mother's guardian or conservator. Power of attorney, guardianship, and conservatorship do authorize broad decision-making power, including financial interests and estate. Durable power of attorney is sufficient to authorize a family member to sign an arbitration agreement. If you hold power of attorney for a nursing home resident and you sign an arbitration agreement, it's likely the agreement can be enforced against the resident. If you have signed a power of attorney document and do not want your agent to have this power, we can update your power of attorney document with special language. The judges in the Barrow case overlooked Elizabeth's parent-child relationship with Scott and her request that he act on her behalf in the admissions process, even though that relationship further enhanced his authority to act as her agent in the nursing home admission process. In other cases, courts could still say the nursing home resident or the person signing for them freely chose to sign away the resident's rights to go to court and use the alternative dispute resolution of arbitration instead. There are dozens of decisions that must be made when a nursing home admission is necessary. Our before, during, and after a nursing home admissions checklist will help you gather information when a nursing home admission is going to be necessary. Call to schedule an educational meeting if you want guidance during the admissions process, including Medicaid eligibility to cover the cost of long-term care.